We finally have a ruling in the Jones versus Abel case, which, if you don't remember, is the case between the publicists. Jen Abel is one of Justin Baldoni's publicists who used to work for Stephanie Jones, the former publicist. Stephanie Jones is alleged to have colluded with Blake Lively on getting the Wayfarer party's communications improperly and outside of legal process. Stephanie Jones filed a motion to dismiss Jennifer Abel's amended counterclaims, so we're going to take a look at what the judge said about those. We'll go over this a little more in depth later on, hopefully with Omar, but I'm just going to, go through the main points today. The motion to dismiss was granted in part and denied in part. This case arises out of a dispute between Blake Lively and Justin Baldoni, among others, that is at issue in related litigation before this court. Familiarity with the proceedings is presumed. For the purposes of this motion, the court assumes as true the well-pleaded allegations of the counterclaims. All right, so we know about Jones' works, we know about Abel. I'm going to skim over that. I'm going to guess he didn't mention Stephanie Jones' psychic in here. Here he's talking about the collapse of the relationship between Jones and Abel when she decided to leave Jones' works, then the start of the PR crisis involving Wayfarer and Blake Lively. Disputes arose between Abel and Jones regarding the management of the Wayfarer/Baldoni account, including regarding Abel's recommendation that Wayfarer and Baldoni hire Nathan. In early August 2024, Jones inserted herself into the mix, seeking to box out Nathan and Abel. But after Jones contacted a reporter from the Daily Mail on August 8th about a story it had published regarding Baldoni and Lively, Wayfarer instructed Jones to cease all activities on its behalf for the time being and to let Abel and another LA-based JonesWorks employee handle Baldoni's PR crisis alongside Melissa Nathan. Now remember, she didn't exactly follow their instruction, so that became a problem. Here they're talking about when they took Jen Abel's phone and how Abel never heard from them again, even though she was supposed to get her phone number released so that she just get the same number on a different phone. With Abel's iPhone in hand, Jones and JonesWorks were able to access Abel's iCloud account and bypass the password protection that would otherwise bar their access to obtain her private communications. No later than August 21st, Jones allegedly disclosed to Lively, her husband Ryan Reynolds, and her public relations consultant Leslie Sloan, private communications drawn largely from Abel's iCloud account, which were accessible through her confiscated iPhone. Shortly thereafter, Abel asserts that Jones took the further step of transmitting Abel's stolen communications directly to Sloan, Lively, and Reynolds. Abel alleges that Jones and JonesWorks provided the communication to Lively through what Abel characterizes as a sham lawsuit. And this is where they're talking about Vanzan. Once the lawsuit was filed, the Lively parties used it to issue a subpoena to JonesWorks for all data stored on Abel's phone, including private communications from her iCloud and email accounts, as well as potentially privileged information. Since there were no identifiable parties and no party had been served, the subpoenas were issued without notice, depriving Abel of any knowledge of the subpoena, much less the opportunity to object. The same day the lawsuit was filed, Jones warned a departing employee not to work for Abel because her business wouldn't be around much longer. Upon receipt of the subpoena on or about October 1st, 2024, Jones and JonesWorks surrendered the entire contents of Abel's iPhone communications to Lively. Vanzan never requested the assignment of a judge, never substituted the Doe defendants for named parties, and never served the complaint on any defendant. The only docket entries for the case are the complaint and a notice of dismissal filed on December 19th, the day before Lively filed her complaint against the Wayfarer parties. Abel alleges that as a result, Jones and the Lively parties now possess the full contents of her iCloud and email accounts, including her photos, text messages, and emails. We're going to skim over the procedural history. We're familiar with that. Abel's first counterclaim asserts liability under the Computer Fraud and Abuse Act. The CFAA makes it illegal for any individual to intentionally access a computer without authorization or to exceed authorized access and thereby obtain information from any protected computer. Likely because of the deficiency in her pleadings, Abel has abandoned her CFAA claims in her brief in response to the motion to dismiss. Courts may and generally will deem a claim abandoned when a plaintiff fails to respond to a defendant's arguments that the claim should be dismissed. The court therefore dismisses count 1 of Abel's amended complaint with prejudice. Okay, now we're talking about the Stored Communications Act. This was enacted to prevent hackers from obtaining, altering, or destroying certain stored electronic communications. Jones argues that Abel's cause of action under the SCA must be dismissed because she provides only conclusory assertions that her messages were accessed while in electronic storage as required by the statute. Abel responds that her allegations that JonesWorks accessed her communications through cloud-based servers owned by Apple are sufficient. Whether or when cloud-based services such as iCloud qualify as electronic storage in the context of text exchanges is a novel question. The important distinction for the purposes of the SCA is between those communications that are stored or downloaded on a device, which are not covered by the Act, and those that are accessed while stored in a covered electronic storage facility, which are. Even accepting that accessing messages from a cloud storage facility such as iCloud would be covered by the Act, Abel has not plausibly alleged that JonesWorks accessed her messages in that way. Abel's relevant allegations are conclusory and do not make plausible the inference that the messages accessed were in electronic storage. She pleads that Jones was monitoring and intercepting her private communications in real time via iCloud, and that messages produced to the lively parties were drawn largely from Abel's iCloud. But Abel references no messages or communications she believed to have been obtained in that manner. Her own allegations support the contrary inference that JonesWorks accessed historical messages via the phone itself, and not messages via the cloud. Abel also points to no messages that might have been accessed only by some other method other than through the physical phone itself. The only specific messages referenced by Abel in her counterclaims are from before JonesWorks recovered her phone. Although the court must generally accept as true all of the factual assertions in the complaint, it need not do so where the allegations are conclusory or where they are contradicted by the complaint itself. Count 2 of the admitted counterclaims is therefore dismissed without prejudice. Now we're talking about the Federal Wiretap Act. The key to liability under the Wiretap Act is the term intercept. Jones moves to dismiss the claim on the basis that Abel has not alleged any contemporaneous interception as required by the statute, as she alleges that Jones viewed the messages after they were already in her accounts. So basically they would have to obtain it while it's being transmitted from one person to the other. Abel responds that her allegation that Jones read the messages through iCloud in real time are sufficient to state a claim. Abel has alleged that Jones and JonesWorks monitored and intercepted her private communications in real time. Her only relevant allegation, that the messages were monitored and intercepted in real time, is conclusory and tracks the requirement of the statute itself. She alleges only that Jones was intercepting and monitoring all of her text exchanges, including not only with her clients, fiancé, doctors, parents, and friends, but also with the undersigned counsel. Abel does not include any allegations as to which messages were intercepted and when or by which means they were accessed on the cloud and not from the phone itself. Basically, the problem is that they're not reading them until after they are already on the physical phone. So they're not intercepting the messages. They're reading them after they've already been downloaded. So he dismisses this one without prejudice because she doesn't show that Stephanie Jones intercepted her communications. Here they're talking about the state law stuff and the choice of law, which I'm not going to really get into right now. I think that's something that I should go over with someone who knows what they're talking about. So I'm not going to do that this second. All right, now we're talking about California Penal Code Section 502. This imposes liability on whoever knowingly accesses and without permission uses any data, computer system, or computer network in order to wrongfully control or obtain money, property, or data. Jones first argues that Abel has failed to state a claim because she has not alleged a scheme and artifice to defraud as required by the statute. That argument is without merit. That Abel has not alleged a scheme to defraud says nothing about whether she has sufficiently alleged, as contemplated in Part B, whether the Jones parties accessed her phone to wrongfully obtain or control her data. The Jones parties argue also that Abel's allegations under the California Penal Code must be dismissed because she had not alleged a sufficient connection to California. Abel responds that she is a California resident, that the phone was seized and its data accessed in California, and that therefore the acts occurred at least in part in California. The Jones parties argue also that Abel has not alleged the kind of damages required by the statute. Abel's allegation as to damages include that, as a result of Jones' malicious scheme, Abel's life has been turned upside down, her career and reputation have been destroyed, her private information leaked, and her email inbox and social media pages filled with a daily stream of death threats and abuse. Abel here has also more concretely alleged that she has spent time restoring her phone number and iCloud information and investigating the unauthorized access. Abel has adequately alleged knowledge on behalf of the Jones parties that their access to her phone was without permission. She alleges that she provided her passcode for only the limited purpose of facilitating the transfer of her number, and that afterwards the Jones parties could access her phone only because they retained access to her iCloud account without her permission. Furthermore, she alleges that because they had the iPhone in hand, the Jones parties could bypass the password protection that would otherwise bar their access. Those allegations must be read together, too, with others in her counterclaim. For example, that using a personal phone at a public relations job is common practice, and that JonesWorks had no policies that gave it the right to monitor her phone, and that her willingness to port her personal phone number into her work phone was predicated on her reasonable expectation that she would retain sole and exclusive access to its contents and her private data and accounts. The Jones party's motion to dismiss the fourth cause of action is therefore denied. Okay, now we have invasion of privacy. Abel next claims that JonesWorks and Jones violated her privacy by hacking into her personal communications without authorization. The Jones parties argued that there can be no tort here because there was no reasonable expectation of privacy. Abel voluntarily ported her personal cell phone number into her work phone, which was a company-owned device. Although Abel consented to porting her phone number to and using the work phone, it is nevertheless plausible that employees in the public relations industry, similarly situated to Abel, objectively retain a privacy expectation in the content of a work phone. Abel explains that it is common practice for PR firms to assume the cost of their employees' phones and phone usage. And unlike a standard work phone or a work computer, Abel's work phone was configured with her personal Apple ID and populated with all of her personal email accounts, photos, texts, third-party apps, etc. In sum, plaintiff has at least raised a plausible inference that she had a protected privacy interest in the relevant communications. The Jones parties argue next that even if she had a reasonable expectation of privacy in her work phone, her allegations as to the use of those messages was not sufficiently offensive. Taking into account all the pertinent circumstances, Abel has failed to state a claim. She argues that the accessing, reading, and disseminating of her private communications and personal data for the purpose of humiliation and harm could be found by a jury to be highly offensive. However, she does not plead facts to support her conclusions. The most specific allegation in Abel's complaint on this issue includes a screenshot of a communication between Abel and a fellow employee. The content of that message indicates that the Jones parties shared with the employee what Abel had been saying to others about working with the employee. That message does lead to the inference that the Jones parties viewed or shared intimate information about Abel or information about Abel's personal life. Abel's unsupported allegation that they were disseminated in the office is not alone sufficiently offensive. Although offensive use of the private information access is not an absolute requirement, merely pointing to a risk that others had access to her personal messages does not state a claim. At base, Abel does not specify what information was accessed and read from her work phone. In the absence of such allegations, the court cannot infer that the sharing went beyond what would be permissible under the circumstances in which the information was shared, and thus that the Jones party's intrusion would be highly offensive to a reasonable person. Abel also brings a false light invasion of privacy tort claim. False light is a species of invasion of privacy based on publicity that places a plaintiff before the public in a false light that would be highly offensive to a reasonable person, and where the defendant knew or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the plaintiff would be placed. Abel argues in her brief responding to the motion to dismiss that the Jones parties selectively disclosed her private communications to create a misleading impression of Abel's involvement in a supposed smear campaign, which JonesWorks knew was false. However, her counterclaims contain no such allegation. The closest they come is at paragraph 93, in which Abel alleges that the messages revealed were modified with slicing, dicing, cherry-picking, massaging, and in some cases outright alteration. Absent any non-conclusory allegation as the false light cast on Abel, she cannot state a claim. Abel's fifth and sixth cause of action is therefore dismissed without prejudice. Now we're getting into conversion. Abel alleges that she has a possessory interest in her phone number, which she provided to JonesWorks with the understanding that she would retain use of it and that it would revert back to her upon departure from the company. She continues that Jones and JonesWorks committed the tort of conversion when they took possession of the phone number and refused to release it when she demanded its return upon her termination. Jones alleges she has a possessory interest in the phone number and that upon joining JonesWorks in 2020, she had owned, controlled, and used the phone number for about 20 years. To that end, Abel has established also that she has a legitimate claim to exclusivity. Nowhere in their briefing did the Jones parties argue that while Abel's number was ported onto the company's phone, it would somehow be used by anyone other than Abel or was affiliated with anyone other than Abel. Abel alleges that she ported her personal phone number onto her work phone on the understanding that it would revert to her upon departure. She made clear that upon her departure, she no longer consented to having her personal phone number ported to her work phone and requested that it be returned to her as soon as possible. Abel alleges that her inability to access her phone number cut off her access to critical accounts protected by two-factor authentication, and that it took her over a month to regain control over all her accounts. It is a plausible inference from the counterclaims that Abel expended time and money in pursuit of retrieving her phone number. The Jones party's motion to dismiss the seventh cause of action for conversion is therefore denied. And then we have emotional distress claims. Abel's eighth and ninth causes of action are for the intentional and negligent infliction of emotional distress. The Jones parties argue that Abel has not met the high bar for emotional distress necessary to plead either its negligent or intentional infliction. Abel alleges that she was in panic and despair after JonesWorks failed to release her telephone number. She alleges, too, that her life has been turned upside down and that she lives in fear of what is to come, given the vast troves of personal data in the possession of these hostile actors. As a result, she alleges suffering extreme emotional distress and mental anguish. The allegations are not sufficient to state a claim. First, it is not sufficient that Abel subjectively experienced emotional distress. The test has an objective component. The emotional distress must be of such substantial quality or enduring quality that no reasonable person in civilized society should be expected to endure it. Jones and JonesWorks argue also that even if she could meet the objective standard of distress, Abel has failed to allege that she was subject to sufficiently outrageous conduct to state a claim under California law. Abel alleges that Jones and JonesWorks had access to everything stored in her phone and shared her private messages with the entire office, mocking and disparaging her. She alleges, too, that JonesWorks monitored her communications and that she lives in fear knowing they have access to that data. She further alleges that Jones humiliated Abel by announcing, per her psychic, oh no, we did get an appearance from Stephanie Jones' psychic, per her psychic, that Abel would soon be pregnant with twins and that she referred to Abel as a 12-year-old drama queen. Finally, Abel alleges that it was only under duress that she signed documents given to her by lawyers that would permit them to access her laptop. As discussed elsewhere in this opinion, Abel's allegations as to interception and monitoring are conclusory, without any further elaboration on what was monitored by who or when, or what was intercepted by who or when. This court cannot draw the reasonable inference that the defendant is liable for the misconduct alleged. Her allegations collectively are also insufficient. Abel's 8th and 9th causes of action are dismissed without prejudice. Abel's 10th and final cause of action is for promissory fraud. This permits a plaintiff to state a cause of action in tort when a defendant fraudulently induces him to enter into a contract. Abel's fraud claim is based on her allegations that JonesWorks induced her to hand over her company phone on the promise that it would return her personal phone number to her, but that JonesWorks breached that promise. She alleges that JonesWorks never intended to perform the promise when it was made, and that the company intended to and did dupe Abel into giving up the iPhone and passcode so as to access, copy, and disseminate, without authorization, the private data stored on the device and information from accounts accessible from the device. The Jones parties argue that Abel could not have been duped into returning the iPhone, as it was a device owned by the company. That argument is a red herring. Abel acknowledges that JonesWorks owned the physical device, but her claim is that she was duped into returning the iPhone in advance of wiping the personal information from her phone, deregistering her personal iCloud and email accounts, and securing her personal and private data. Abel does not allege that she owned the phone, but rather that absent JonesWorks' promise, she would have only returned the phone after removing her personal data from it. She states that JonesWorks gave express confirmation that it would release the phone number if she went straight to Verizon, but that it did not do so, and after hours, she left the store in a panic and despair. California courts have found that such hasty repudiation of the promise, or a failure to even attempt performance, is the kind of circumstantial evidence that a court may rely on in making inferences in the plaintiff's favor. The court may also draw such an inference from the fact that JonesWorks assured Abel and Verizon that they were in the process of effectuating the release and to bear with them for a few minutes upon her arrival at the Verizon store. That allegation is indicative of continued assurances after it was clear that JonesWorks would not perform. At least from the pleading stage, Abel has alleged enough to push from possible to plausible the inference that JonesWorks intended to repudiate the promise when making it. Finally, the Jones parties argue that Abel has not sufficiently alleged damages as required for promissory fraud. As discussed, JonesWorks owned the physical phone, so Abel cannot claim damages based on the value of the phone itself. Instead, she alleges just that, as a direct and proximate result of the alleged promissory fraud, Abel was harmed. The allegations as to loss are largely conclusory, as Abel does not point to any specific losses caused by the fact that she could not use two-factor authentication, and as she alleges, the proximate cause of public disclosure of any messages that resulted in damages was the subpoena issued in conjunction with the alleged sham lawsuit. Abel's allegations do not permit the court to make a plausible inference that she suffered damages caused by the actions she took in reliance on the defendant's misrepresentations. If JonesWorks was not going to return the phone to Abel promptly, nothing about the promise that induced her to turn over the physical phone could change that. Abel would have been required to turn over the company-owned phone regardless. Thus, Abel would have suffered the alleged damage even the absent of the fraudulent inducement, and so causation cannot be alleged and a fraud cause of action cannot be sustained. So this was denied without prejudice. So the only thing that was dismissed with prejudice was the first cause of action, which she abandoned. So she has a chance to fix some of these, as well as some of them, the motion to dismiss was denied, so that means she's fine there. Abel has until October 31st to replead the dismissed causes of action, addressing her deficiencies elaborated in this opinion. All right, guys, like I said, I'll get more in depth about that later when I have someone with me who can help walk me through some of the law stuff. But that's all I got for now, so thanks for watching, and I'll see you all soon.